go on the record in People versus Jennifer Leo. This is two files. We have file number 55429 65514. If I could have counsel put your appearances on.
Sierra Coke on behalf of the people.
Thank you, Honor. Mertz on behalf of Ms. Lee. Ms. Lee was here.
Mr. Kermer, how did we want to proceed in this Leo's case today?
Yeah, Ms. Lee was going to accept a plea offer in this matter. So file number 255429 actually will be dismissed in its entirety. She would be pleading guilty to count 1, possession of meth as a half third, count 2, being contraband into the jail as a half third, and count 6, maintaining a drug house as a half third in 5514C. The remaining counts of that file will be dismissed. I do have an advisor rights that I've executed with Ms. Lee as well, Judge. Ms. Lee is on parole. She understands that these sentences would be consecutive to any sentence that she will receive from the parole board. She knows that she's not getting credit for the time she's sitting at school.
All right. Did you say 1, 2, and 6?
1, 2, and 6, yes, sir. And then the trial set for Monday on the other file, the first file, 5429 will come up with that.
And again, with the habitual, what is the?
Half third.
After.
Okay. That says to just count 1 because, no wait, count 1, 2, 2 is a felony as well, so it would apply to count 2.
And to count 6, that's 2-year high court sentence.
Okay. Okay, Ms. Koch, is that a correct statement of the plea offer?
It is, Your Honor.
Ms. Leal, have you had an adequate opportunity to speak with Mr. Attorney about this plea?
Yes, sir.
And is that how you wanted to proceed today?
Yes, sir.
You raise your right hand, please. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank
Thank you.
So Ms. Leal, you were on parole at the time that these offenses occurred.
Yes, Your Honor.
So you understand that you would not be entitled to any jail credit and that any sentence in this file would have to run consecutive or back to back in any sense that you would have or else you would ask for a parole violation.
Yes, Your Honor.
And then in this file 265514, you're going to plead guilty to 1 count of possession of methamphetamine as a habitual third offender. That means the maximum penalty phase would be up to 10 years and or $30,000 fine. Do you understand that?
Yes, Your Honor.
And count 2, which is possessing contraband in the jail as a third habitual offender, that means that would be up to 10 years and or $2,000 fine.
Yes, Your Honor.
And count 6, which is maintaining a drug house, that would be a maximum possible penalty of up to 4 years and or $50,000 fine.
Yes, Your Honor.
All of those things in mind, including the parole sanction, what is your plea to each of those charges today?
Guilty.
Right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf here at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you want it. You understand all those rights.
Yes, Your Honor.
You understand that you're going to be giving up and waiving all of those rights by pleading guilty.
Yes, sir.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it, you would have to ask for the Court of Appeals to hear your case. If they said no, then that would be the end of any appeal. You understand that?
Yes, sir.
Has anybody threatened you with anything to get you?
No, Your Honor.
Has anybody promised you anything other than what we said here before?
No.
Is it your own free choice to enter this plea?
Yes, sir.
Are you pleading guilty to these charges because you are actually guilty?
Yes, Your Honor.
So the information I have says that this happened back on December 4th of 2025 on or around that time frame. Is that correct?
Yes, sir.
And at that time, were you here in Crawford County?
Yes.
And did you have possession of some methamphetamine at that time?
Yes.
And you know that that's what that was?
Yes.
Did you have any legal right to have any amount of it at that time?
No, sir.
At some point during that time frame, were you lodged here at the Crawford County Jail?
Yes.
And after you had been taken into the jail and lodged here, have some fentanyl in your possession?
Yes, sir.
Did you have any legal right to have any amount of that?
No, sir.
And also at this time frame, I don't know, Mr. Gerber, I'm not sure what Ms. Leal's role was in the drug house.
I can ask her some questions.
Sure.
Ms. Lee, while you were here in Crawford County, you were residing at a residence, correct?
Yes, sir.
And there were individuals that were frequenting that residence,
Yes.
and you allowed them or knew they were coming there to do drugs,
Yes.
and drugs were being used in that residence?
Yes.
I think that establishes the elements for me to be the on this judge.
And that place was located here in Crawford County.
Yes, sir.
I would agree that that is a basis for the plea.
Thank you. Aware of any threats, promises, or inducements other than what's been placed on record?
No,
No,
Your
Your
Honor.
Honor.
I don't know if we should just inquire of Ms. Leela for 2 prior convictions to establish the official term numbers.
Are you, Mr. Murphy, is there any dispute about the prior convictions?
There isn't.
Ms. Felker, you're satisfied based on the stipulation that there are at least 2 prior felony convictions?
Yes.
Thank you.
All right. Counsel, are you both satisfied then that the court has complied with statute and court will take?
The defense is here.
I'm satisfied, Your Honor.
The court finds, Ms. Leal, that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support the finding that you are guilty of each of these charges. The court will accept your guilty plea as to all 3. We'll set this matter for a sentencing hearing. Between now and then, there'll be a pre-sentence report prepared. You'll have a chance to go through that with your attorney prior to the sentencing hearing. Do you have any questions at all?
No,
Your
In
Honor,
light of the plea today, the court will adjourn the jury trial term set for Monday, February 9th, in file 255429. Mr. Gerber.
No, Ms. Leela is requesting a bond modification. She's sitting at that time. She's on a parole detainer. Ms. Lee took some initiative to enroll herself into a treatment facility. Her guideline range, by the low end that I've scored her is 19 months, so she knows there's a prison sanction likely with these offenses, but meanwhile, she's asking if the court would allow her to go to treatment before it imposes any sentence. She would like the court to hear her arguments regarding bond.
Okay.
So she's taken initiative to enroll herself and get an admission to Bear River Health or the Lions Den, whichever the court would approve. They would pick her up, they would get her treatment, and she would certainly then be back here in person for sentencing. But in this dead time, while we wait for about 4 to 6 weeks for sentencing, she'd like to get some tools under her belt for treatment. She's had an extensive drug history. She hasn't had treatment regarding drugs. Ms. Lee tells me if she goes back to prison, there's drugs back in prison, and it doesn't help her with recovery. So she'd like to enroll in treatment if the court will allow.
Your Honor, Miss Leal has been in and out of this court system for many years. And frankly, she looks great today. You can tell that she's clean and doing well, but it doesn't make sense to allow her to be released pending a prison sentence. I think she had just gotten out of prison. I would defer to Mr. McFeld if you could tell us the date, but it's pretty clear that's where she's headed back. So to release her, I think is probably not the way, the order in which things should be done normally. The treatment centers want them to go at the end of their sentence. So then they're out and they can utilize those tools, not getting those tools to go to prison. So I think based on her criminal record, which is very, very extensive, that it wouldn't be appropriate, and not because I don't think she needs it or that she could do well in it, but this is just not the time to do it. Thank you.
Yeah, so what I was thinking, Mr. Grimmer, as you were articulating that request, is exactly what Ms. Phillips just said. I don't think now is an appropriate time. I do believe treatment is something that I would consider that part of sentencing. Let's see where your guidelines end up.
Yes, sir.
But between now and sentencing, I think it's gonna put you, I don't think it would be a productive thing until we figure out exactly what.
Yes, Your Honor.
Know that, so the fine will remain as it is, and we'll go forward with sentencing. We'll get it scheduled as quickly.
Yes, Your Honor.
Thank you. Ms. Leeds requested that I be present at the pre-sentence interview with the Department of Corrections, so I'll let Mr. McFarland know. I can zoom in for that.
Sure.
Thank you. Good luck, Ms. Leeds. I'll talk.
People versus Brinker, file number 255411. Mr. Brinker, please come forward, please.
Sierra Coke on behalf of the people.
Rob Brinker. Yeah, Jason Thompson, I'm standby counsel, but Mr. Brinker representing
The record should reflect Mr. Brinker present here in the courtroom today. Brinker, I'm sure we've gone through this before. You know, you have appointed standby counsel. If at any point you want to consult with Mr. Thompson, to stop the proceeding, to be able to talk with him, just let me know.
Appreciate it.
I'm happy to give you as much opportunity as you might want or need to consult with him. That aside, is it your wish to represent yourself here today?
Yes, sir, that's, yes.
Okay. This is currently set for a jury trial next week, to begin on February 13th. And today is a final status conference. So Mr. Brinker, today would be the time to enter into any plea agreements.
Yes, yes, sir. I met with Ms. Coke last week, or the week before last, and we came up with an arrangement for a plea negotiation, so everything goes okay. But they're ready to move forward with that.
Okay, so can you tell me what that was?
Your Honor, the offer in this case was operating while intoxicated, third offense, dismiss the habitual and DWS. Mr. Brinker wants to take advantage of that offer. He asked if the court would be willing, and I don't object if the court sets it on the first week of May for the sentencing.
Second week.
He has his final exams in school and wants to finish it. This is the closest he's ever gotten to finish school, but this court's very familiar with Mr. Brinker, so if the court wants to do that, I wouldn't object. He's doing fairly well on bond, better than he usually does. Thank you.
What does fairly well mean?
I think he's on a tether, an alcohol tether,
Yes, ma'am.
and he has not had any positive alcohol tests. He's showing up for court. This is also new for Mr. Brinker. So if the court wants to do that, that's fine. If the court doesn't, that's fine as well. I've talked to a standby counsel about it as well.
That's not part of the plea agreement, or is it?
I discussed it with her. I graduated from Kirtland with an associates, and I'm graduating summa cum laude in electrical engineering, the program there, and it finishes in May. And you know, I said it was okay. You know, I know the sentencing will be around like March. If it's already postponed that for like a couple more weeks so I can graduate. I put 2 years in, and I've been working really hard. You know, trying to better myself. I've been in treatment the whole time as well, not court ordered or nothing like that. I've been for 2 years consecutive, and I got documentation there that back that up as well. If you'd like to see it. Haven't been in any trouble or nothing like that. I've been just trying to be a good man, go to school, and that's what I've been doing. And I finished the 2-year program in May 10th at Walk. And I'm a straight A student, second in the whole college right now. Whole program.
So Ms. Coke, the alcohol monitoring said that's being done by a SRAM unit or something?
Yes, sir. It's on me right now.
Bond
Yes,
commission.
sir.
Yeah, it's a bond condition.
How closely are you able to monitor that?
Um, he's supposed to be sending the information into the court. That's the best information. I haven't gotten, usually if he violates the, court or the company will contact me and I have gotten nothing, saying that he's violated, which is impressive for Mr. Brinker, given
Your
his
Honor.
history. And
Your Honor, he is on parole with me. He sees me every 2 weeks and I communicate directly with the Scramnet company. So if there is any kind of a violation, it comes right to me.
Okay.
He's also been drug testing twice monthly and he's been clean in that regard too.
Okay. All right, so Mr. Brinker, I am willing to schedule the sentencing out. I'm just gonna say though, and Mr. Haven, I'm gonna ask that you notify my office if there's any violations. of those
Yes, sir.
things. So Mr. Brinker, if between now and May, you have any issues with drug or alcohol testing, then
Sure. I haven't touched drug in 4.5 years.
that's good.
4.5 years been.
I want that to continue.
Yes, sir. Yes, sir.
We all do.
Yes, sir.
I just want you to understand that if there's any positive testing between now and May, I'm just gonna set the sentencing right away.
I understand that
The
completely.
school won't matter. to me
Yeah,
anymore.
but 100%, I understand. that.
All right. So aside from that, is it your agreement to go forward with the plea to operating while intoxicated as a third offense with enhancements and the license suspended, charge being dismissed?
Correct, Your Honor.
Okay.
Yes, sir.
Do you need any more time to discuss that with Mr. Thompson at all?
No, no, sir. Me and him discussed it thoroughly at his office.
Okay,
Yes, sir.
good. Can you raise your right hand, please? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Mr. Brinker, you're currently on parole, is that correct?
I'd have been off parole if it wasn't for this, and I was supposed to get off in December, and he had to extend it because I was been in case of this, like, I get off parole right now. But it wasn't for
Bobby,
this.
the question was, are you on parole?
Oh, yes, 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 sorry.
Mr. Haven, has there already been a parole violation sanction issued?
Yes, there was, and the violation has been, the sanction's been issued. It was deferred to the court. So,
Okay, so there aren't going to be additional sanctions for violating the parole,
correct.
but Mr. Brinker still would not be entitled to any jail credit, is that correct?
That is correct.
So you understand that, Mr. Brinker?
Yes, sir.
Okay. And the maximum possible penalty for operating while intoxicated as a third offense is up to 5 years and or a $5,000 fine. Do you understand that?
Yes, sir.
You have a question about that?
Sorry. No, sir. Okay, yes, sir.
Okay. With that in mind, what is your plea to that charge today?
I plead guilty, Your Honor.
Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you if you're at trial to question those witnesses. You have the right to have the court order any witnesses on your behalf if you're at trial. You have the right to remain silent during a trial and to not have that silence used against you. Right to testify at a trial yourself if you want it. You understand all those rights.
I do, Your Honor.
You understand that you're going to be giving up and waiving all of those rights by pleading guilty.
I do.
Also, you don't have an automatic right to appeal the plea that you're making here today.
I understand that.
If you wanted to try to do that, you'd have to ask for the Court of Appeals to hear your case, and they could say no, and that would be the end of any appeal.
Correct, Your Honor. I understand that.
Has anybody threatened you with anything to get you to plead guilty?
Couple times, no, no, sir.
Now's not the time to joke.
I know it isn't. I know it isn't. I'm just trying to, I'm nervous, so I do.
It's okay to be nervous, but I
Yes, sir.
has anybody promised you anything to get you to plead guilty?
No, sir.
Is it your own free choice to enter this plea?
Yes, sir.
Are you pleading guilty because you are actually guilty?
Yes, sir.
This happened back on August 13th, 2024, is that the correct date?
Correct.
On that date, had you been consuming alcohol?
Yes, the night before, I said yes.
Okay. After you consumed alcohol, did you operate a vehicle on M72 here in Crawford County?
I did.
And did you have any blood or breath tests to determine the level of alcohol in your system?
They didn't, oh yeah, they did a blood test at the hospital.
Was it above a 0.08?
I'm uncertain on that, but they did a injection or they took my blood. Yes,
Do
sir.
you know what the result was?
0.212.
0.212. Do you have any reason to doubt the accuracy of that test?
I don't.
Okay. Had you consumed enough alcohol that you believe that your blood alcohol level was above the 0.08?
Yes, I do.
Had you previously been convicted of operating while intoxicated in 2021 in the 87C District Court?
Yes,
And of operating while intoxicated in June of 2023 in the 86th District Court?
correct, Your Honor.
Ms. Coke, are you satisfied with the factual basis?
Yes, Your Honor.
Ms. Coke, are you aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Are you satisfied that the court has complied with statute or rule in taking this plea?
Yes, Your Honor.
Mr. Brinker, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. This matter for sentencing in mid-May, will be notified at the date, time of that.
Okay.
It's important that you keep the court updated with any changes in your address so that that notice.
Yes, sir.
Yeah, I was just considering, I believe I will be.
So just make sure that you stay in touch
Yeah,
with Mr. Haven in terms of your parole and give instruction.
yes, sir.
If you have any questions at all.
No.
If there's any violations of the bond, our office will prepare an ex parte motion and ask for a bench warrant. I'm just putting that on the record so he's aware of it.
And then the court will adjourn the trial date currently set for February 13th. Today.
Thank you, Your Honor.
Thank you.
Okay, People versus Eric James, case number 255484.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Jason Thompson on behalf of the defendant, Eric James.
The record can reflect Mr. James is present here in the courtroom today. Mr. Thompson, how did you want to proceed on this file?
I believe first we have to review the competency report that the court received. Correctly, we're at, court received a competency report that assessed that Mr. James was competent. Just stated the record, his mom was also an evaluation done for criminal responsibility that determined he was criminally responsible. There is a plea offer in this case, Your Honor. Mr. James asked me to ask the prosecutor if she would agree to go into the guidelines, and she declined that. So the plea offer is just to the straight charges.
Count 1 and count 3 as a habitual second and count 7 as an operating while intoxicated. I'm sorry, count 1 is possession by a felon. I said that wrong. 1 and 3.
Mr. Thompson, is that a correct statement of the plea offer?
That is, thank you.
All right, in terms of the competency issue, Mr. Thompson, are you objecting to the conclusions in the report, or are you requesting an independent evaluation?
Personally, I don't think that was a proper evaluation, and, the lady that did the evaluation on screen, it was, she kept getting my cases mixed up from here to over there, like she didn't know which case was what, and all, any of that, so I feel I didn't get a proper evaluation, to be honest with you.
Okay.
So that's my opinion. I mean, I have a right to that, but I feel I didn't get a proper evaluation.
Okay. So, what's interesting is the fact that you're aware enough of what's going on that you don't think you got a proper evaluation,
Yeah.
to me, kind
I
of
mean-
shows that you understand what's going
I mean,
on.
I understand that my rights and everything, but I'm capable of going to trial and all that, but at the time, I wasn't on my medication, any of that. It's just, I mean, I'm guilty of this crime here, but I didn't get a proper evaluation for over there at Mama Renzi, which I wasn't, you know what I'm saying, at the time, I mean,
Yeah, and I think he's mixing things up, and I would say on the record, I think he clearly is competent. Whether or not he has a criminal responsibility in Mount Morency is not an issue for our case.
exactly, and that's what I'm saying, they mixing it up, like he's saying that Mama Renzi is saying I'm competent, but I only talked to this lady one time, and they're saying I talked to her numerous times, I only talked to her one time, and
Well, I'm only dealing with the charges here, so I don't have anything to do with what goes on in Montmorency. And the finding in this case here is that you are competent, that you understand what's going on with your case. And you certainly appear to me here this morning to understand what's happening.
yeah.
So we just need to decide whether or not there's an issue regarding competency here. And so I'm trying to understand, Mr. Thompson, do you need a second to talk to your client about this?
I may think.
Okay. So, Mr. James, we're gonna pass this for a minute. I'm gonna give you a chance to talk to Mr. Thompson a little bit more about this competency issue. Okay. We'll come back on the record.
That's fine.
Okay, so I'm gonna have you go right back over there.
And Mr. Trish suggested pieces of the
Mr. Cyan, are you able to hear me okay?
I am, Your Honor.
All right, we're gonna get started with your case in just a second. Mr. Trush, are you able to hear me?
Yes, Your Honor, I can.
Sorry, I was muted there. I called the case and Ms. Koch put on her appearance. If I could just have you put your appearance on, please.
Thank you, Your Honor. Richard Trush, appearing on behalf of Mr. Cyan.
Thank you. This is the date and time set for sentencing in this matter. Mr. Trush, have you had a chance to go through that pre-sentence report with Mr. Cyan?
We have had an opportunity to go through it.
Mr. Cyan, did you have an adequate opportunity to go through that report and talk to your lawyer about that?
Yes, Your Honor.
All right. Mr. Trush, are there any additions, deletions, or corrections?
No, Your Honor.
Are there any challenges to the scoring of the guidelines?
No, Your Honor.
Ms. Koch, do the people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the scoring?
No.
Anything on behalf of the people for allocution today?
Your Honor, the facts are pretty well laid out in the PSI. I think the recommendation is appropriate. I would ask the court to follow it. Thank you.
Mr. Trush, anything on behalf of your client today?
Yes, Your Honor. So I think the PSI outlines some things that I think become pretty clear. I think for the most part, again, the PSI here is fairly well written, and I think they have a relatively accurate capture of Mr. Cyan in here. But I think what lies beneath the surface in regards to this case is this is really what addiction looks like. We have in here, and it's identified at several points in here, he struggled with addiction for a long time. He struggled with substances. And I think Mr. Cyan will be the first person to tell you he hates this substance. He hates methamphetamine, but he can't break the grip that this has on him. And that's consistently what he has, when I have talked to him, that's what he's reported to me, and emotionally. It continues to lead him down this path that gets him in trouble, and continues to lead him down this path. And he has periods where he's successful and he kind of gets away from it and it pulls him back in. And that's what addiction looks like, right? That is what we see, is periods of success followed by periods of struggling. And, there's ups and downs. And, I think that's the picture that's painted here by the PSI. And the question I think the court has to address, and there's some procedural things with this case, but I mean, the question for the court to answer, in my opinion, is what's the right response to address somebody who has an addiction problem, right? What is the correct response? How do we address addiction? My suggestion to the court would be, I don't think that addiction is best addressed in MDOC. I think that what we wind up having happen when we send someone to MDOC is we often make the addiction worse. We know, although we try to tell ourselves drugs aren't available in MDOC, we know they are. We see people routinely come out of MDOC and they're put in a position where they have to rebuild. And that often leads them to go back to the same places and the same triggers that cause them to get into this situation in the first place. The situation here is one that I certainly think that there needs to be a punishment element to what's gone on, what's occurred. I would suggest to the court that I think the court can craft a sentence that contemplates county jail as opposed to MDOC. The benefits I think that the court has with that type of sentence is, unlike MDOC, where again he's going to reach a point and he's paroled and again, whatever the court imposes, then he reaches that point, he's released, he's paroled, and he's back out in the world. The court can craft the sentence here using county jail time, where we have more tools and more control to kind of compel him into treatment. And I say compel, but realistically, if the court were to impose a year in the county jail, which would be on the lower end of the guidelines, the court could make him eligible in the last 30 days or last 60 days to go into a treatment program. That gives him a great incentive to address the addiction issue and puts him in a position when he's released to be more successful because he could go from that setting to a sober living house or any number of other different things. What's likely to happen if the court imposes an MDOC sanction is that he's going to be released from MDOC into MDOC housing, which unfortunately is often surrounded with a lot of people who are not interested in making changes. And then to briefly address some of the procedural quirks here, the PSI addresses Mr. Cyan bonded out of the Crawford County Jail so that he could address the violation that he had to deal with over in Roscommon. The Roscommon violation has been dealt with. I think it is accurate. I don't know that his bond was ever formally canceled when he went over to Roscommon. I don't think the court has to ignore that since the start of this case, there's been no point in time where he hasn't been in jail. When the Roscommon violation was ultimately dealt with and completed, Emmett County came and picked him up on an open warrant. Again, the warrant that was contemporaneous. It's not as if it's a new charge in the sense of him committing a charge, while on bond or anything. It was an existing warrant that he didn't know about that happened contemporaneous to this. But again, for those reasons, I think that the court could craft a sanction in the county jail, which would serve both Mr. Cyan's interest and the community's interest better. Thank you.
Diane, anything you wanted to say today?
First, I'd like to say thank you, Mr. Trush. He said it pretty much best, speaking from my perspective and my perspective of coming from addiction, an active addiction since the age of 13. I did have some success in sobriety. I did 6 months of Harvard Hall and sober living, tossing plastics, but I did have a lot of psychological and emotional issues going on. My wife is 7 years. Was cheating on me while I was doing 12-hour shifts. I found out the baby that was just born, she's currently 18 months old, wasn't mine. She was also in active addiction, and it was just a little bit too close to home. And once that ball got rolling, it was just hard for me to get back into active recovery. Just something I should have stuck with. I should have did sober living. I shouldn't have put myself back in the surroundings. I thought she was doing better than what she was, and two addicts living together just don't work out. I do apologize on my conduct and my and I plan on doing recovery either way when my time is through, whether it's court ordered or not. I plan on doing sober living and staying on track this time around.
All right, thank you. Mr. Cyan, I did read through the report. I'm familiar with the circumstances that bring you before the court on this case, which are concerning from the standpoint that, at least from the information contained within the report, this isn't a circumstance where this was just a personal use issue. You had enough methamphetamine, 26 grams, which is a fairly large amount, certainly enough to indicate trafficking. The way it was found, packaged up, this wasn't a situation where you just had some and were found in possession of some methamphetamine that you were using for yourself. It's pretty clear from the report here that you were engaged in selling that methamphetamine to other people. I'm aware that a lot of times that occurs to support your own habit, but nonetheless, taking that extra step of getting larger amounts of it, selling it to other people, you're compounding the damage to the community in that you're making it available for other people to continue with their own addictions and their own problems. So that's an aggravating factor here. I'm also familiar with your background and your circumstances based on the information in the report. There's no doubt in my mind based on that you do have a significant substance use issue. It does appear that you've made a lot of attempts, both court ordered and otherwise in the past, to address that. Based on the information in the report, it looks like you've done at least 5 different outpatient treatments, 5 different inpatient treatments. So there's been a lot of efforts towards recovery in your case over the years, going back, according to the report, to going all the way back to 2005. So almost 20 years with varying degrees of success. You've been on probation 5 prior times. You've had 10 prior local jail sentences. So there's been a lot of efforts through probation, through community sanctions to get you on the right track and keep you on the right track. And those have been unsuccessful over that period of time. I'm really glad to hear that you're going to pursue recovery, whether that's court ordered or not. I think you're at the point now, at least from my standpoint, where continuing to commit court resources and community resources towards that is probably not appropriate anymore, given the number of times over the length of time that that's been attempted unsuccessfully. But that doesn't mean that you can't work on it on your own. And I think it's at the point now where it's clear that the court making you do it isn't going to work and hasn't worked. So I think now you need to decide that you want to do it for yourself, whether it's ordered or not. And so in that regard, I'm glad to hear you say that, because I think that's going to be the key for you going forward. At this point, though, I don't see any advantage or any value to a local sentence. I think you're at the point now, again, given the number of times on probation and local jail sentences, where the guidelines call for a DOC sentence that's more appropriate. So the court finds that the recommendation is a reasonable recommendation. I think it accounts for your prior history as well as your conduct in this case. The court is going to follow that recommendation and sentence you to the Michigan Department of Corrections for a period of 24 months to 30 years. You do have credit for 68 days served. The court is going to order a crime victims assessment of $130, court costs of $325, $50, and $68 state cost. You do have the ability to seek an appeal of this sentence. If you haven't received it yet, you will receive some papers which explain to you what your appellate rights are, as well as how to request a court-appointed attorney to help you with any appeal. The time limits on your appeal won't start running until you actually receive and acknowledge those papers. Mr. Trush, is there anything further that we need to address on this case from your standpoint?
I would just indicate the court provided the advice of rights to my office. We've sent it over to the Emmett jail. I don't know if he's received it yet, but that has been sent over there for him.
Okay. All right. Thank you. That's all for today. And Mr. Cyan, the court is going to disconnect this time.
Thank you, Your Honor.
People versus Shelby Sunday, file number 255436.
Sierra Coke on behalf of the people.
Good morning, Your Honor. Jody Dope here on behalf of Shelby Sunday, who is here with me.
Okay, the record should reflect Ms. Sunday's presence here in the courtroom today. This is the date and time set for sentencing in this matter. Ms. Sunday, have you had an adequate opportunity to go through the pre-sentence report and talk to Ms. Dope about that?
Yes, sir.
Stoke, are there no additions, deletions, or corrections that you have?
No, we read the report together, and Ms. Shelby did not indicate that there was anything that was incorrect in the report. I did not find anything that was incorrect.
And are there any challenges to the scoring?
Misdemeanor, Judge.
It's a misdemeanor, so there wasn't scoring.
Okay. Ms. Koch, any additions, deletions, or corrections?
No, Your Honor.
Anything on behalf of the people for allocation?
Your Honor, I struggle with these cases where we send them to sobriety court because I know sobriety court is difficult and it's a difficult thing. It's the recommendation here, I think, was 5 days with 1 day credit in the probation to finish the sobriety court. So I hope she's very successful in that. You know, she had a prior OWI in 2013, and then she had another OWI in 2019. Then she had a DWLS that got dismissed in 2025. So I don't know what needs to happen in her life for her to take this seriously, and I hope that sobriety court does that. Otherwise, she's probably looking at significant jail time. So thank you, Your Honor.
Mr. McDowell, do you have a copy? Left it in my office. I know I read through it prior to the hearing. Okay, thank you. Ms. Doe, anything on behalf of yours?
Yes, I want the court to know, this case has been proceeding for quite some time. It started in February of 2025. We had the ice storm, and Ms. Shelby hired me during that, and there was some delay in the proceedings then, and then we've had substance abuse evaluations and some things happen, but the amount of time that has elapsed has allowed me to get to know Ms. Sunday pretty well. She's invested herself in being sober. She's not had any slips since this incident happened. She's dedicated to a sober lifestyle. You're out. And I think that's a big difference. I think before she wouldn't have admitted that she really had a problem with alcohol. Today, she knows and understands that she does, that she can't go back to that lifestyle. Something that is going to be difficult for her is that she does not have insurance that covers the counseling for sobriety court. So she has to pay out of pocket $120 a session for a counselor over the next year, anytime that they're requiring her to do that counseling. That amounts to right around $500 a month in expenses for her, in addition to testing expenses and other expenses for the program and fines and costs from this court. She has $200 to put towards fines and costs today. Would ask that the court would allow her to make a payment plan to the court after that because of the significant expenses that she's going to incur in sobriety court. She was talking to me this morning about asking the court to try to fashion some alternative to jail time. Although I told her I believe that the statute says that the court has to impose jail for 5 days. She wanted me to request some sort of house arrest because she really wants to be able to work to try to save money so that she can afford all of the expenses for sobriety court. So that is her request today, that the court would consider perhaps giving her house arrest so that she could continue her employment over the next 4 days. Although she has prepared herself to come today to serve the days that were recommended. And I did tell her the court could exceed those days in its discretion. But I think she's made great efforts during the time that she's been under bond, and we would ask just those possible options from the court and the court's discretion. And I know that she does have something to say as well.
All right, thank you. Sunday, anything you wanted to say?
Yes, Your Honor, I just want to say that I apologize for putting the court through this and myself as well. And if I were able to be on house arrest or anything else I'd be able to do in order to not have to serve so I can get back to work tomorrow. And also, I've already talked to the probation officer in Sheboygan County about having to pay out of pocket for my sobriety court. So they're aware of it and also are working with me and being able for me to work the days I need to work and also get through my sobriety court and successful with it.
All right. On the Sunday, I did read through the report prior to the hearing today, so I'm familiar with the circumstances that bring you before the court. I'm also familiar with your background and so forth based on the information in that report. I take all of that into consideration along with what the lawyers and yourself had to say here today. Certainly the circumstances that led to your arrest here are concerning. Had a fairly high blood alcohol content at the time. Certainly pose a danger to yourself, other people who on the road. So this business like restarted and you ended up. So very dangerous situation. Operating vehicle with that kind of alcohol content, back roads as you have. So that's certainly concerning. I do think though, that there's certainly the potential for rehabilitation here. Sobriety court, as acknowledged by the lawyers, it's not an easy road. I used to preside over a sobriety court, so I know that it's very challenging. And it takes a lot of commitment on the part of the people who are participating. And what it really takes to be successful is for you to want to do it for yourself, not just because it's a better way out of the charges or because the court's requiring you to do it. It's because you don't want to wind up in this situation again. You want to use all the tools that are available. So I hope that's how you take it, how you go forward with it. I hope that you are successful in that. I think there's every indication that you could be. And so I hope that is the way that it goes. And I'm going to follow that recommendation. In terms of the jail time, the statute is what it is. It says you got to do 5 days. Because you're going to participate in this program, I'm not going to impose any additional jail time over of that. Although I think the circumstances of this offense could call for more jail time. But because I do see the ability for rehabilitation. So I am going to follow the recommendation. The court is going to sentence you to probation for a period of 2 years. The court is going to adopt as the conditions of your probation all the terms and conditions listed in the report. The most important of which, of course, is that you participate in successfully complete the Sheboygan County Sobriety Court program. The court is going to order that you serve 5 days in the Crawford County Jail with credit for 1 day served. That time be served up front beginning today. Court is going to order restitution in the amount of $100 payable to the Crawford County clerk to be dispersed to state police. Crime victims assessment of $130. Court cost of $325. An OUIL reimbursement fee of $150 that will be dispersed to the prosecutor's office. The DNA testing fee of $60 and a $50 state cost. Mr. McFalda, do we impose a supervision fee when?
I didn't recommend one just because her participation in sobriety court, I just felt like they will be doing the majority of supervision. I thought it would be just an added expense.
Okay. So that is listed under paragraph 17, but I'll strike that. The court's not going to impose a supervision fee. And then Sunday, in terms of the court costs, it's $200. That's something that the court, do community service or citizen do, as opposed to the other costs are statutorily required to impose. So I can think about those. So, but to the extent that we can waive or reduce the court costs based on community service or some other way, talk to your sobriety court agent about that. I'm certainly willing to consider waiving that and doing something else to help with the fight. I know it's a big financial burden.
Thank you.
You do have the ability to seek an appeal of the sentence and the scope that you tell it right on the table there. If you can on this Sunday review those and just acknowledge receipt.
Sure. I'm handing her the notice of right to the review.
Just make sure they're hers, because I just put them in a pile.
They're stapled together.
Yes, yep. So I'm just making sure that her name is on there because everybody's is together.
Oh.
Yes.
Oh, I see.
And then just for the record, the court has signed the memorandum. Oh, that's right. Okay. Sorry.
Jody, there's no appellate rights because it's a misdemeanor.
It's a misdemeanor, so there aren't
Sorry.
appellate rights.
Okay, yeah, there's not one there with her name on it.
I'm thinking we're dealing with the third here.
Right.
So this Sunday, there's nothing that you're going to receive in writing, but you do have the ability to seek an appeal of the sentence. If you wanted to do that, you would file for that appeal within the next 21 days. If you have further questions about that, talk to Ms. Doge. Explain that process to you. Ms. Polk, anything further that we need to address today?
No,
Just, does she then need to report to both places for probation? She'll need to report to this court and to sobriety court?
I will discuss that with her when I go over her probation order, probably tomorrow.
Okay, so she'll need to report to you initially then?
I'm gonna see her at the jail tomorrow. She'll
Okay.
be there. That'll be easy for me to see her, go over her probation order, and then what I'll do is transfer her up to Sheboygan. The agent up there with the Department of Corrections may just place her on administrative because sobriety court, but I'm gonna let them work that out. Every
Appreciate it.
county does it a little bit different.
All right, thank you. I appreciate that clarity.
I'm deciding to hand it over to the officer now, if they'd like to go forward.
Thank you, Your
You
Honor.
can grab it.
Thank you. Have a great day.
We're just gonna take a quick 5-minute break. We'll be back on the record in about 5 minutes. Okay. Leland, is Ms. Leland here? Come up to the podium, please. We'll go on the record. People versus Kimberly Leland, file number 245281.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Jason Thompson, duty attorney. I did receive a copy of the amended probation violation. I just want to make sure we're all working on the amended one. And discuss it with Ms. Leland and Mr. McFalda. Mr. McFalda offered that if Ms. Leland is pled guilty to technical violations, count 1, count 2, count 3. And the one on the bottom that says count 1 should probably say count 7. The one that's occurred on 2-4, the use, that he would dismiss counts 4, 5, and 6. That would be 4 violations, so that would give the court discretion in sentencing up to the maximum on the original charge, which is possession of methamphetamine. My understanding, Ms. Leland wishes to plead guilty to this.
Right, Mr. McDowell, is that a correct statement?
That's correct, Judge.
So 1, 2, 3, and 7.
Yes.
Ms. Leland, have you had an opportunity to speak with Mr. Thompson about this? Okay, is that how you wanted to proceed today? Can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Ms. Leland, understand that by pleading guilty to the probation violation, that it could subject you to the maximum possible penalty on your underlying charge, which is up to 10 years and or $15,000 fine. Do you understand that? I need you to speak up a little.
Yes.
Thank you. You understand that you have the right to have a hearing as to whether or not you violated your probation, and that by pleading guilty, you're going to be giving up that right?
Yeah.
And is it your wish to proceed with this guilty plea here today? You raise your, did I already swear you in? Okay. Has anybody threatened you with anything to get you to plead guilty? Has anybody promised you anything other than what we said here in court today? Is it your own free choice to enter these pleas? Are you pleading guilty to violating your probation because you did actually violate your probation? All right, so let's start with count 1. Back on December 10th of 2025, you were on probation out of Crawford County, is that correct?
Yeah.
And you were aware that one of the conditions of your probation was that you were to not use or possess any controlled substances unless they were prescribed to you. Do you understand that? On or about that date of December 10th, 2025, did you use methamphetamine?
Yeah.
Was that something that was prescribed to you?
No.
Were you also ordered at that time to participate in substance abuse treatment?
Yeah.
Did you fail to follow through with that?
Yes.
Back on January 19th of 2026, you were still on probation. Is that correct?
Yes.
Were you aware that one of the conditions of your probation was that you were to participate in drug testing as directed by your agent?
Yes.
Did you fail to appear and test for drugs on that date of January 19th?
Yes.
Okay, and then February 4th of 2026, you were still on probation, is that correct?
Yes.
On or about that date, did you use methamphetamine?
Yes.
Did you have any prescription or any legal right to use that at that time?
No.
All right, thank you. The court finds that the plea is knowing, voluntary, accurate. The court is satisfied there's a factual basis to support a finding that you did violate your probation as alleged. Court will accept your guilty plea as to each count. In terms of sentencing, Mr. McDowell, were you going to prepare an updated report?
Yes, Judge.
Okay. So we'll set this for sentencing at a later date. Between now and then, Mr. McDowell, you're going to meet with him to do updated pre-sentence report, and the court will set this for sentencing. Mr. Thompson, have you talked to Ms. Leland about appointment of counsel? I know you're appearing today for purposes of arraignment.
We did not discuss counsel for sentencing.
Okay. Ms. Leland, did you wish to have an attorney represent you at the sentencing hearing? Okay, so the court will refer Ms. Leland's case for appointment of counsel.
And Your Honor, I didn't I wasn't aware of this file before I came in this morning. Who is the attorney on the underlying case?
Looks like you.
You were.
Okay, I'll be appointed on this, Your Honor.
Oh. All right, so the court will order that Mr. Thompson be appointed to represent the purposes of sentencing. We need to address bond in that sentencing.
Judge, yeah, I would like to address bond. I do think I think a high cash bond is appropriate in this matter, Judge. You know, she pled to possession of methamphetamine. Remind the court that she was a co-defendant on a case where there was 324 grams of methamphetamine in the car and a loaded handgun. She was a passenger driving north from down south with all these narcotics in the car. She's really had nothing but problems since she's been on probation, not complying with, you know, various orders. I actually could charge her with several other accounts of failing to appear for her counseling. I do think a bond is appropriate. There is going to be a jail recommendation. As far as her sentencing, I think she should be held pending sentencing.
All right, Your Honor, I would ask the court to take into consideration Ms. Leland voluntarily appeared today. I mean, she knew she'd been having the troubles with the testing that brought us here today, but she still appeared today in court. I believe she's historically appeared. I don't have the file in front of me. Would ask the court to take that into consideration.
All right, so Ms. Leland, you were just placed on probation in the middle of November. You were given the benefit of a really light sentence given the nature of the crime here. You were sentenced to time served, which was 37 days at that time, placed on probation. It appears that probation has not really gone very well so far. You have not been compliant. The court also notes that over a 1 year period, I believe that you were absconded. There was a bench warrant out for your arrest. I think that was issued in January of 24. You weren't brought before the court arrested until October of 2025 or September of 2025. So a significant period of time that you were absconded in this case. So for those reasons, I do find that a high bond is necessary to ensure your appearance. I also think it is likely that you're going to face some jail time. And so I agree with Mr. McDowell. The court is going to set bond of $50,000 cash or surety. And then we'll set this for sentencing before the next available date. And so the court officer right now. And we'll proceed with sentencing when the court get that scheduled. Is Mr. Wakely here? Dale, People versus Wakely, file number 255479.
Sierra Coke on behalf of the people.
Good morning, Nicholas Robinson on behalf of Mr. Wakely. Come up to the podium right now.
All right, we have this set for a jury trial set to begin next Tuesday, February 10th. This is the final status conference and plea cutoff. Mr. Robinson, have you had an opportunity to speak to your client about the plea cutoff?
We have, Your Honor, and Mr. Wakely would like to exercise his right to a trial by jury.
Okay. So we'll proceed with trial as scheduled next Tuesday on this file. I look, we also have the stack with Doreen.
We do, but this case actually was charged 4 months before Doreen on 5/20/25 and is a capital case. Doreen is an FH and this is an FC. So we'd ask that Mr. Wakely's trial go. We are prepared.
Okay. I mean, it's capital because of the individual, but it's not a capital charge.
Right.
All right, so I do think it would be appropriate to proceed with this file. It has priority over Doreen. So we'll move the Doreen, we schedule that one, and we'll proceed with trial scheduled. Ms. Koch, I'm not sure, have you already submitted your jury instructions?
No, they'll be submitted today. It's a pretty straightforward case. The only foreseeable issue I see for the jury trial is that the case has a search warrant The search warrant was the result of multiple controlled buys into Mr. Wakely. So there may be issues in the trial where there are questions regarding that may be an issue, but that's the only legal issue that I foresee in this trial. It's very straightforward.
I agree with that, Your Honor. We have not filed our instructions either. We'll have that in by tomorrow at the very least.
So I'll just ask that both sides submit any instructions in Word format, because I need to edit them. Mr. Robinson, it's not necessary for you to submit a full set of instructions. If you can just review this, folks, all I really need you to submit are ones that you object to, disagree with, or alternate or additional instructions.
Very good.
And if you can provide those electronically to my office. And to Mr. Robinson, just typically, I don't know if you tried a case in my court. Got it
I've
or
done
not.
one with you.
Have you? Okay,
Yeah.
so you know, we start right with jury selection, go right into proofs as soon as we get jury selection. So,
No problem.
okay.
Out of curiosity, what's the weather expected to be like up here next week?
That's a good question. I haven't looked that far ahead.
Not bad.
Cold. All right, cold and snowy, I think if we count on that.
Okay,
Safe.
fair enough.
So yeah, I'll just ask both counsel and Mr. Wakely if you get to be here and ready to go by 8:30 on the morning of trial, and we'll get started. Ms. Coke, anything else to address?
Nope.
Oh, Your Honor.
Thank you.
Thank you very much.
Versus Anthony Doring, file number 255475.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Jason Thompson on behalf of the defendant, Anthony Doring. Your Honor, we were here, we heard the court's ruling about the order of trials. We have no objection to that. We just asked that our trial be reset. I would ask that the final status another final status conference be cut off, be extended. I think Ms. Coke and I might possibly have just a little bit more talking to do, given some recent events. But I think essentially we were prepared for trial. I believe we'd already submitted our jury instructions with this exhibit list. It's going to be a straightforward trial, and I don't foresee any problems with getting this done in one day. Okay, Ms. Coke.
We are ready to proceed to trial. We can just move it. I can continue to talk to Mr. Thompson. We've talked numerous times regarding this case, and I'm sure we'll continue. If we want to do a final status conference, since we're moving it, that would be appropriate too.
Okay, I will do that. Ms. Cope's still one day.
Yes.
Mr. Doring, did you have any questions about how we're going to proceed?
No, sir.
Thank you. Just make sure that you continue to stay in touch with Mr. Thompson.
Yes, sir. Thank you.
All right, thank you, Your Honor.
He's in the box.
Mr. Thompson and Mr. Trombley. Sir, what's your name?
That's Mr. Wilson, Your Honor. Mr. Joel Wilson has a sentencing later. I don't see Mr. Trombley. I can go call him lobby.
Yeah, if he's here, we can take his case now. We're just waiting for Mr. Trush.
What?
The Trombley bond out in Roscommon.
I have no idea.
And Rachel sent a writ.
No, what?
All right, we'll just take a short recess then. Mr. Trush, are you able to hear me okay?
Yes, Your Honor, I can.
Right, we'll go on the record in People versus Phillips. This is file number 255438. The record should reflect Mr. Phillips is present here in the courtroom today. If I could have both counsel put your appearances on.
Sierra Cook on behalf of the people.
Thank you, Your Honor. Richard Trush appearing on behalf of Mr. Phillips.
Okay, Mr. Trush, did you have a chance to go through the pre-sentence report with Mr. Phillips?
I have, Your Honor.
Mr. Phillips, did you have an adequate opportunity to go through that report and talk to Mr. Trush about it? All right, Mr. Trush, I know that we have some challenges to the scoring. We'll address that in just a second. I did also receive communication from the Lions Den. I had a chance to review that, just so that you're all aware of that. Mr. Trush, I also received a letter from Russell Anhilami in regards to Mr. Phillips. I also received a letter from, I believe, your daughter, Ms. Choniak. Yes. Okay, I had a chance to review that. As well as from your father, Gary? Yes. So I did receive all of those ahead of the hearing today, and I had a chance to read all of those. Mr. Trush, before we get to the scoring challenges, are there any other additions, deletions, or corrections to the CSI?
No, Your Honor.
And then in terms of your challenge to the scoring of OB 15, is there anything you wanted to say to the record on that?
Just to highlight here, Your Honor, I mean, this is a somewhat unique, I think a unique scoring in the sense that we don't have this charged as a delivery type offense. I don't think there's any objective criteria to point to. We're not talking about a controlled buy. We're not talking about individual packaging, scales, buy money. I mean, we're really not talking about any of the objective criteria that we normally are looking at when we look at that type of thing. I mean, really what we're basing this on is purely the amount of, the amount of the substance that was found. And I don't know that we can get to a preponderance of the evidence based on that. I think that we start to get into the question of we're asking now, how much is he using on a daily basis? We're getting into the question of, how long was this supply intended to last? I just don't think that we can get to a preponderance of the evidence based on that criteria. I don't think the scoring of OB 15 is appropriate.
All right, just vote.
Yeah, this is a significant amount of methamphetamines, but what I would point to is Mr. Phillips' circumstance at the time and the cost of buying that and the way to finance it. He was living in commercial placement. He spent most of his life in and out of jail. I don't know when he had been released from prison, but it had been fairly recently. I mean, we have his employment history and his living expenses. So for someone to have this much methamphetamine for personal use and be able to afford it it's not at all practical. I mean, this isn't like talking to a jury where juries might believe that somebody had this much meth on hand for personal use. It's clear from the amount of methamphetamine that it was a significant cost to him. And the only way he really had to finance his situation was to sell this methamphetamine. So the standard's low and I defer to the court, but this is a lot of meth. Thank you.
All right, Mr. Trush, any response to that?
I mean, I guess I would just indicate, to me, I mean, the best indicator here of, the lack of preponderance of the evidence, I mean, the standards aren't exactly the same, but I mean, this wasn't charged as a delivery. If there was probable cause to believe that this was possession with intent to deliver, I mean, it wasn't charged in that manner. I mean, I think that's tacitly the prosecutor acknowledging that she can't meet the burden to show that it was a delivery amount, that it was possession with intent to deliver. I think that is a very relevant consideration for the court to look at there. Thank you.
All right, so OB 15 involves aggravated controlled substance offenses. It allows for the scoring of 5 points where the offense involved the delivery or possession with the intent to deliver any controlled substance, which we're not dealing with that as a sentencing offense here. We're dealing with possession. Not delivery or intent to deliver. So that leaves us with the second sentence under 5 points, which is or possession of controlled substances having a value or under such circumstances as to indicate trafficking. And that's a pretty broad statement and could include lots of different types of conduct. I read the pre-sentence report very carefully here. There's not a whole lot of information. The description of the offense is, maybe a couple of short paragraphs. So there's not a whole lot for the court to go on other than the weight, which was, I believe, 19 grams, which is certainly more than what would be considered a daily use amount. I mean, in and of itself, it's not in the scope of cases that the court sees. It's not, I would say, a strikingly large amount, certainly, again, more than what we would consider for daily use. But the circumstances here, as I read them in the report, is there were a number of individuals at this residence. I think based on other cases that I've had with these individuals, Ms. Leal, Ms. Henning, I've had both of them in my court arising out of this incident, that there was a lot of people there with a lot of drugs there. So I don't know that there's enough information for the court to go on that all 19 grams of those were necessarily Mr. Phillips, or that they were being trafficked. I think it's an equally likely scenario where this was just a whole bunch of meth that a bunch of people had access to and were using, as opposed to a situation where Mr. Phillips was trafficking out of that residence, again, based on the information that I have. So if we're just relying on weight, I don't think it meets the preponderance standard. I think there would have to be other factors there that the court could use to rely on to qualify as circumstances to indicate trafficking. So I really think it's a burden of proof issue. I think there's some evidence certainly that was going on based on the weight and value, but I don't think there's enough evidence for the court to conclude that it meets the preponderance standard. So the court will grant the challenge, and the court will score OB 15 at 0 points, which brings us to an OB level of 10, or OB total of 10. Does that change in and of itself? I don't have the grid in front of me. Mr. Trush, does that change the range?
Your Honor, I have the grid in front of me. That would still remain at level 2, at least at this junction.
Okay. So then your second challenge was to OB 19, and Mr. Trush, any oral argument on that?
So, Your Honor, actually, since drafting the challenge and ultimately filing it, I've actually thought about this issue quite a bit, and I think there's two pieces of this puzzle to look at. And the first piece of the puzzle is really sort of what I've outlined in the brief. And again, admittedly, when I wrote this, I didn't think about the other side of it. But the first piece of this is Mr. Phillips, what I'll call post-offense conduct. The post-offense conduct, I don't think supports the scoring here. What we have is Mr. Phillips ultimately informs the police when talking to them that they missed something at the house. He informs them, hey, you missed some drugs there. He tells them where it is, how it's packaged so they can find it. And I think there's no part of that to me that suggests interference with the administration of justice. To me, that suggests the exact opposite. He is being cooperative. And frankly, that's consistent in my experience with Mr. Phillips in regards to this and other matters I've represented him represented him on over the years, also just other interactions I've had with him in my prior capacity as a prosecutor over the years. My experience has been that, frankly, once the cat's out of the bag, Mr. Phillips is usually fairly cooperative. He's usually pretty willing to admit what he's done once, he's confronted with it. So I don't think there's anything in the post-offense conduct that would support it. And now the question that I think the court will have to sort of grapple with is, can the pre-offense conduct potentially support the scoring? And that is to say, if the department's position or the prosecutor's position is the simple fact that these drugs were hidden there in the first place represents attempted interference with the administration of justice, I think that's something that the court would have to assess. But I think that it's most likely that that's not what's going on here. And what I mean is, I think it's equally as likely that if this substance, if he hid this substance, if he's in fact the person who hid it, that it's more likely hidden not out of, fear of trying to hide it from the police raid that may or may not occur, but just because it's a substance that has value, and that's often how it's treated. Right. I mean, we know that people often keep controlled substances in lock boxes or, in disguised containers and hidden. Again, I don't know that rises. I think it's clear that the post-offense conduct does not rise to the level of supporting the scoring. I'm not convinced that the pre-offense conduct would support that either. Again, even if the court were to get to the point and find that he's the person who did those things pre-offense.
Thank you, Ms. Coe.
I'm not sure, and I looked at the sentence a couple of times because I didn't get this until I didn't have a chance to review it until yesterday. I got it the day before. But that in the police report, it says that Sergeant Copadlo informed me I had missed some narcotics and they went back and searched it. I don't think that Mr. Phillips was the person that informed them they forgot that they had missed it. I think he informed another inmate who informed the sheriff. But either way, Mr. Phillips' circumstances at the time is the problem, because he's living in commercial placement and he's subject to parole search. So the question is, why are the narcotics hidden? And they're hidden because it's not like a regular person where they could possibly get a search warrant. Somebody could tell on him and they could show up. He is regularly searched in his commercial placement because of his conduct and how he was on probation in a commercial placement. So I think that's why it was scored for 19. Normally somebody probably couldn't be scored in this circumstance. And I certainly wouldn't argue it if it was just a regular person that they got a search warrant for, because people probably don't think about what could happen if somebody gets a search warrant. But he was subject to regular searches in that placement. I think that's why the drugs were hidden. And so I would defer to the court. And I think if the circumstances were just one of my average people, I wouldn't even make any argument at all. And I would agree with Mr. Trush. So thank you.
Yeah, all right. So reading through the report, I mean, the way it's written here is that the defendant revealed to another inmate, and then law enforcement was informed. So, Mr. Trush, I don't know how accurate your factual assertion is that Mr. Phillips was being cooperative or somebody wanted to help law enforcement by revealing to them that they missed some substances. Because if it went through another inmate, that kind of torpedoes that argument. And then Mr. Trush, I mean, I don't doubt your assessment of Mr. Phillips and his motivations and the way he's behaved in the past or how he comes across to you. I don't think that's something the court can rely on as an evidentiary basis for either finding or not finding factual support for the scoring of a offense variable. So looking just at the information that I have, there clearly was some additional substances that were there at the time of the search that were revealed later. Mr. Phillips, in my view, at least from a circumstantial evidence standpoint, I think the court can infer that he knew about those substances at the time. He revealed that later. The fact that they were hidden and not revealed at the time, I think does provide a factual basis from hundreds of the evidence standpoint that there was an interference with the administration of justice. So the court finds that OB-19 is properly scored. For that reason, the court will deny that challenge. And so that leaves our scoring again at the previous range, which is 1947. Mr. Church, did you have any additional challenges to the scoring?
No, Your Honor.
Ms. Coke, do the people have any additions?
No,
Do the people have any challenges to the scoring?
no.
Anything that we got?
I always wonder when I see somebody who's, you know, in their fifties and still in these circumstances, at what point they're going to realize that maybe this isn't the lifestyle they want to lead. And certainly Mr. Phillips is not there yet. When you look at his history, which includes multiple convictions for delivery, controlled substance, you know, he's on parole. You look at his lengthy criminal history of 12 felonies and 13 misdemeanors. His PRVs are almost double the highest that they can be. They're 135. And of course, that's because he's got all these high severity deliveries. I don't know why somebody in this circumstance who is, you know, out of prison, you know, subject to MDOC, living in commercial placement, so they gave him housing. You know, he had the chance to make better life decisions and he frankly did not. I think he's earned, you know, the higher end of the guidelines because he doesn't seem to have any interest whatsoever in getting his act together and becoming a productive member of society. Because I think at 53 years old, we're not having the same discussion about people whose brains aren't developed for good decision making. We were talking about a man who's been around for a long time and knows exactly what he's doing. Thank you.
Thank you, Mr. Church.
Thank you, Your Honor. I don't dispute a lot of what the prosecutor says here, and I think honestly part of what she said is very well taken. You have to ask yourself when we have a person in front of you of Mr. Phillips' age who's still engaged in this conduct, what's going on? And the, you know, the prosecutor frames this and says, you know, that he, you know, has he decided this isn't the life he wants to live? And I don't quite think it's that simple. I was going through Mr. Phillips' history and I counted more than 15 substance related offenses in his history. And frankly, that wasn't even all of them. And that's not even taking into account the offenses that are substance related, but not on their face, right? We all know that there can be you know, a theft offense that's substance related that on its face doesn't appear that way. I think what this is, you know, this is a picture of what addiction looks like. Mr. Phillips has engaged in treatment. He has made efforts to change things. And when I talk to him and he's sober, he expresses that. You know, he has told me, and again, the court has the information from the Lions Den. You know, he's expressed to me how a long-term program would be good for him because we know that we see people released, and we see people go back to the same patterns, which is to say, I think Mr. Phillips, unfortunately, hasn't quite recognized at this junction that, you know, the saying in recovery, right? You have to change one thing, everything. I think that he goes in with intentions to make changes, but what he does is find himself surrounded by people who are not looking to make the changes, and he finds himself falling into old patterns and old routines, and that happens. The recommendation here is for 36 months, which is the higher end of the guidelines here. I would suggest to the court, I certainly can understand how that recommendation could come about. He has been accepted in and has the opportunity to take advantage of a long-term treatment program in the Lions Den. I would suggest to the court that I think that is a better use of resources than sending him to MDOC. Even if the court imposed a lengthy county jail sentence and allowed him to go into the program following it, I think it makes the community a better place. The community's interests are served by Mr. Phillips, addressing the substance abuse issue. And I say that not just, he's served by that, but the community is too. Mr. Phillips is a father and a grandfather. And, he's expressed to me how, he wants to be able to be there and be a positive influence for his grandkids, and his daughter. I think that the interests of the community are better served with a lengthy county jail sentence followed by admission into a long-term program. Something like the Lion's Den would be a great program for him. This is kind of last stops for him. As the prosecutor indicated, his PRV level is devastating. I mean, his PRV level means that, almost any offense he commits, he's going to be at the top end of the grid. I mean, so I would suggest to the court, I think the resources in the community are more well served by recovery as opposed to incarceration. Thank you.
Thank you. Mr. Phillips, anything you wanted to say?
Oh, yes, sir. First of all, I in no way intend to stand here and downplay the severity of my crimes, the impact that the things I've done have had on the community for years. And I take full responsibility for what I've done. And I would like to ask you to allow me to enter into this program with a chance to be around the right people for an extended period of time. The new sense of purpose it would give me, the structure this program would give me, and quite frankly, just the platform it would give me to help other people down the road to use my experiences and my knowledge of drug abuse and the problems it causes in people's lives. Now, I've done a lot of research. I've had my family do a lot of research on this program. It's 8 to 10 months of rigorous Christian-based learning. I just know deep in my heart that this is what is going to help me more than going to prison. My life has been a revolving door, going in and out of prison, coming back, getting on drugs. And I know that it looks crazy. You look at and I must look like a lost cause looking at my history, but I'm not. If you let me go into this program, once I graduate after 8 to 10 months, I can stay on and work for them and become a counselor. And I've been doing so much thinking about that. And that's what I want to dedicate my life to that. And I would be good at it. So I can absolutely be not only a productive member of society, but an asset to the community by doing that. So, and I'm just asking you to please let me try to, go into this program and make the changes I need. Because my life, right, I get out and I'm surrounded by the wrong people and I have the best intentions. I've tried so many times. It's been since I was 15 years old, I've been on drugs. And I don't want it anymore. I want to change my life. And I don't see me going back to prison, changing anything. I'll get right back out. It'll be the same exact spot I was in every time. But this program can change my life. And I've always known God has been there. I've just never known how to get past the barriers, the drugs, and the problems they cause in my life keep me from that, So I've done a lot of praying on this, and I hope you can see the sincerity and you give me this chance, because I will make the changes. And this program is the answer. I know it is. It's what I need.
Okay. Mr. Phillips, as I indicated, I read through all the letters that were submitted and the information about the Lion's Den, although I'm familiar with that program already. I read through the pre-sentence report, so I'm familiar with the circumstances, what happened here, pre-sentence information in that report. I'm also familiar with your background and your history, again, based on the information in that report. And, I was certainly struck by the letter to your daughter.
Matter of fact, not to cut you off, I'm sorry, but my daughter went through your drug court program with you and changed her life. Really proud of her. She's got big support right now.
I certainly understand your circumstances and where you're at now and how you got to this point. And, you know, I don't ever say that anybody's a lost cause. I think anybody at any point has the ability to reform themselves, to get the kind of help that they need to address their substance use disorder and the reasons behind that. Usually there's a lot to unpack underneath that. It's not just substance use, that's a patient, other issues that it's covering up. So I don't ever think that anybody's a lost cause or that they don't have the ability to get help and move forward. There's some aggravating factors in your case, as we've all indicated. Your past history leaves you in a situation where you're getting prison recommendations and prison guidelines. The guidelines in this case are 19 to 47. So for the court to sentence you below that, which I would have to do in order to be able to attend the Lions Den or any other program, or would have to have substantial and compelling reasons to go below what the current guidelines are. And I believe that you're sincere in your desire to move on from this point. But there isn't anything else other than what you're saying here in court today in your past behavior and the circumstances that bring you before the court on this charge to indicate that you're going to or would follow through with that. And maybe this would be the one time that you did. But in order for me to go below those guidelines, again, I have to find some kind of substantial and compelling reason to do that. And there just isn't one here other than you saying that it's going to be different this time. And it's hard for me to have confidence in my scheme looking at what I'm looking at to think that this is going to be the time. I think to the extent that once your sentence is served in this case, there's no reason why you have to wait until you're charged with another crime to seek out a program like the Lions Den. There's no reason why when you're released on parole, you couldn't have done that this past time or couldn't do it again in the future. There's no reason why you have to wait for a court to order that or to give you the opportunity for that. You're going to have opportunities to do that. And if you're really serious about it, and that's really the change that you want to make, then I hope that you do that. But at this point, again, your past record is what it is. And they're just, the fact that you're on parole when this happened, there's just really no indication that things would be different this time. Certainly not enough for me to go below the guidelines and the legal standard that I would have to do that. I do think that a sentence within the middle of the guidelines is a reasonable sentence. I think it accounts for your past record or what happened in this circumstance, the fact that you were on parole when this occurred. And so that is the sentence that the court is going to impose, 36 months. Michigan Department of Corrections to 15 years. Because again, of your parole status, you have credit for 0 days served. The court is going to order a crime that is exception $130, court costs of $325, state costs. You have the ability to fill out the sentence. Mr. Thompson can tell Mr. Phillips with his appellate rights. Mr. Phillips, we're going to provide you with some papers that explain to you what your appellate rights are, as well as how to request a court appointed attorney. Help you with any appeal.
Mr. Judge Phillips, John?
Yes.
Sir, you're gonna date an initial here that indicates you've received them. It's not the same as filing an appeal, but it tells you your time limits for filing appeals for 14 days. 36. The 2 sheets that you're gonna keep are the forms you file mailing to start that appeal process. You can both request a court appointed attorney and preserve your right to appeal. So I'm gonna take these top 2.
Just as a housekeeping matter, he's still on this bond revocation warrant. You can please sign.
going forward.
Will I have a chance to see Mr. Truce before anything happens, before I was leaving, or?
Mr. Truce, can you get in contact with Mr. Phillips at some point today?
It is my intentions this afternoon to try to get over to the Crawford County Jail. However, I did want to ask the court, to the extent the court has the authority or ability to do so, is it possible to have Mr. Phillips stay in the county jail for the next 30 days? He still has a matter in Otsego County that we have to resolve. It's currently scheduled. We were trying to get it today, but it's just not going to happen. It's currently scheduled for May 5th, or May. It's been a week, Judge. March 5th. So to the extent possible, can we have him remain in the county jail as opposed to going to MDOC?
I don't have an objection to that, but that's not something I think I can order the jail to do or not do. So I certainly don't have an objection to that, but I think that's something you have to work out with the jail.
And transport set up by MDOC, they likely have already got the recommendation and worked on transport. So the jail sets that up. Just so the court's aware.
Ma'am, can you tell me your name, please?
Miss Misick, you're on.
Leah Misick?
Yes.
All right, we'll go on the record in People versus.
I can't really see. There it goes.
So you can see us now, Miss Misick?
Yes, I can.
Okay. Yeah, I have the file here, if that's helpful.
I'll just put it in. Later. All right, I believe this is a probation violation arraignment today, is that correct?
It is, Your Honor. Ms. Misick had a hearing Monday. She advised she had been experiencing homelessness and had not received the court notice. So she didn't appear for that hearing on Monday. Okay.
Have you had a chance to go through the violation with Ms. Misick?
I did, Your Honor. I believe she wanted a hearing on this. And she has an explanation for what, from her perspective, was occurring.
All right, Mr. McFelder, do we want to go ahead and set this for a hearing?
Judge, I know Judge Hunter asked us to do this as a contempt warrant rather than a violation, so I guess I'm not sure how to proceed on this.
All right, so I'm just going to enter a not guilty plea on Ms. Misick's behalf today. The court will set this for a violation hearing or contempt hearing for her failure to appear. In terms of bond pending that hearing, Mr. McFelder, do you have any input on that?
Well, Judge, she has a pending violation for failing to report to her supervising agent. She's being supervised out of county. And then she failed to appear for court on Monday. So, I mean, I do think some bond is appropriate, Judge.
Your Honor, I understand what Mr. McFall is saying, and obviously the court hearing is, something the court should take into account. I will indicate Ms. Misick reported for probation officer. That's how she came to be under arrest. She advises she has been reporting. I understand there's some disagreement, and we're going to have a hearing about the date she reported, whether she was in substantial compliance or not. But she advises she's been regularly reporting. She has a lot of financial difficulties. She's working on a remodel job where she won't get paid until the end of the job, so she's very low on funds right now, and she'd ask for a $500 bond. Thank you.
All right, the court will set bond amount of $500 cash or surety. I think that's a reasonable amount of bond, given the nature of the allegation here. The court will include all standard terms and conditions of bond, along with all conditions of probation. And then again, Ms. Misick, the court's going to set this for a hearing. You need to make sure that you stay in touch with your probation agent and that you contact the court so that you know what that date and time of that hearing is, okay?
Yes, sir.
Judge, she's having housing issues. The current address I have for her is Boardman Road, Southwest and South Boardman. Does she still want notices sent there, or does she want them sent somewhere else?
No, I need it sent to my mom's address, which I'm not 100% sure on what it is right now, but I thought you guys already had that address because that's where my probation and Travers sends everything.
Miss Misick, is that the address in Fife Lake?
Yes.
10874 Vans Lane?
Yes.
Okay, so I have 10874 Vans, VANS Lane, Fife Lake, Michigan, 49633.
Thank you. She did not update her address with me.
And that's the same address on the summons. Okay, November 5th. All right, thank you.
Thank you. All right, Ms. Misick, that's all for this hearing today.
Okay, thank you.
Is Mr. Trombley present?
And see Mr. Trombley, we do have Mr. Juliet here from Sheboygan County, and he's got a hearing at 1 o'clock. The roads aren't great today.
Yeah, well, we're behind on everything right now. So.
All right.
Your Honor, Mr. Trombley had been in Roscommon County Jail as of January 30th. I don't know if he posted bond on a new charge or not.
This was set for probation violation hearing today.
Yes.
There was a writ for today.
I'm not sure what we'll be able to do on that because they charged him, right?
He did get charged, so.
Yeah, so I don't know that we're gonna be able to do anything on that today.
Do we want to move that hearing out?
I think it makes sense. So the allegations that form the basis of the PV are now criminal charges in Roscommon County that are pending.
Yeah, I think an adjournment would be appropriate for that, Your Honor.
Okay. If we set this out 60 days, that's not reasonable.
I think so. Then we can see where the underlying charge is at that point.
I agree.
Okay, so we'll set Mr. Trombley's matter for another hearing in about 60 days.
It'd be Mr. McGrath, I think.
Sir, are you Xavier McGrath?
Yes, Your Honor.
All right, go on the record as People versus McGrath. This is file number 255423. The record should reflect Mr. McGrath is present today by video from Crawford County Jail. This is an arraignment on some alleged probation violations.
I did, Your Honor, and obviously I'm concerned this could form new criminal allegations. So at this point, Mr. McGrath is going to stand due to the charges.
Okay. The court will enter a not guilty plea, Mr. McGrath, on your behalf with regard to the alleged probation violations. And then the court will set this for a hearing. Mr. Haven, do you have any recommendations regarding the bond pending that hearing?
Yes, Your Honor, these allegations are almost a carbon copy of what his underlying offenses that he's on probation for. And they're pretty serious charges. So I think a fairly high bond would be appropriate.
Mr. Thompson.
Thank you, Your Honor. I did speak with Mr. McGrath. He is requesting court-appointed counsel, and I will be appointed. He does report that he has family. He's got a mother who he lives with, who's local to Crawford County. He has a good job at Cooper Standard that he was able to return to. So he has strong ties to the community and strong incentives to appear to court on this case. So I'd ask the court to set a reasonable cash bond, perhaps a $5,000 bond. Thank you.
Your Honor, is there any way that I could speak on that at all?
Yes, absolutely.
Your Honor, then I would just like to advocate that Mr. Thompson was just saying, that I have every intention on being present for everything that I have to do for throughout this. And these are just allegations at this point. And I would just think that I would really like the opportunity to continue my life and what I do have going on while I have to go through this process, Your Honor. A 5,000 bond, that's something that I've worked at, I would be able to do, and that would just allow me to continue the good things I do have going for in my life, like my good job that I have. And I've been working a long time at my sobriety. I just had a slip up after 130 some days sober, Your Honor. I do have a good head on my shoulders. This probation originally was for drinking violation. And I came in to report to see my probation officer 100%, and did everything I have to do, and I'm going to continue to do everything I have to do. I would just like the opportunity to be able to continue the good things that I do have going for my life while I go through this process, Your Honor. And with a high bond like that, I don't have a lot of money saved up, and I'm not going to be able to post it.
All right, well, the court, looking at the allegations here, which do involve allegations of assaultive conduct, and I would think are likely to result in some additional charges over and above charges for violating your probation. Based on that, the court does have some public safety concerns, so I do think a $5,000 cash assurity bond is an appropriate bond, both to ensure your appearance at future hearings as well as for purposes of public safety. The court is also going to impose all conditions of probation as the conditions of bond, along with all standard conditions. The court is also going to impose no contact provisions with the named victim in this case as part of the bond as well. And then the court will direct this to be set for hearing within 14 days. Mr. McGrath, if you're not able to post bond, you do have the right to have a hearing within 14 days. So the court will set it for a hearing at that time before Judge Hunter, and we'll go forward from there. So make sure that you stay in touch with your attorney, Mr. McGrath, and you'll be notified of the date and time of that hearing.
Your Honor, there's no way that I could please get a 10% on that so I could continue my work, my job.
No, I'm sorry. We're going to schedule that hearing. You can address that with Judge Hunter if you want. You can ask him to modify it at that time. Our hearing today. Ma'am, can you tell me your name, please?
Sandra Stead.
Mr. Juliet, are you ready on this? Yes. Yes. People versus Joel Wilson, file number 255421 and 5485. If I could have counsel put your appearances on.
Anthony Juliet on behalf of people.
Thank you, Your Honor. Jason Thompson on behalf of defendant Joel Wilson.
Mr. Wilson, you can be seated if you'd like. I know you got a health issue there. This is the date and time set for sentencing in this matter. Mr. Wilson, have you had a chance to go through the pre-sentence report and talk to your attorney about that?
I don't believe there's an actual PSI here, Your Honor, because it's a delayed sentence. I just didn't receive it. I'm sorry. This is consistent with the plea agreement, Your Honor.
Okay. All right. Mr. Juliet, do you have any additions, deletions, or corrections to that?
There was just one minor correction on page 1 of the pre-sentence investigation. I believe Mr. Thompson, under evaluation and plan, I believe it says he was retained, but I believe he's assigned.
That is not accurate, Your Honor. I was
Appointed. Okay, so we'll make that correction.
Otherwise, nothing else.
Juliet, do you have any victims that wish to address the court on this case?
No.
Anything for allocution?
Yeah, yes, Your Honor. One of the driving forces behind this plea agreement was there was actually no money that was actually the defendant received. The sheriff's department caught it in time such that the insurance company didn't actually pay anything out. So that was one of the mitigating factors behind the offer for a delay of sentence, understanding that it's still discretionary with the court. One of the aggravating factors is the amount of time that the sheriff's department in this county put into investigating this. I would ask the court to consider that and the lack, well, no criminal history to speak of. So on the whole, I think the recommendation for the delay is appropriate. So I'd ask the court to follow it. Thank you.
Thank you, Your Honor. I do think this is an appropriate resolution. I'd ask the court to adopt it. He has no record. He's an Army veteran. He's a community member. He's a business owner. He has a lot of things going for him. I think he can certainly get past this and comply with probation to be able to have this matter discharged as contemplated. So we are asking the court to adopt the recommendation. Thank you.
Mr. Wilson, anything you wanted to say today?
I apologize for any wrongdoings. And I will. That's time ever ending.
Well, I read through the report, Mr. Wilson, so I'm familiar with what happened in this case. I do think, for the reasons that Mr. Juliet indicated and Mr. Thompson, that the delay of sentence is an appropriate resolution of this. It's going to give you an opportunity to demonstrate over the next year that this was kind of a one-time thing, and you're not going to engage violations of state law of any kind, but especially this type of thing in the future. And if you're able to comply with all of that, then hopefully we'll be back here in a year with a successful discharge. If not, then we'll be back and there'll be a sentencing hearing on the underlying charge, and that could include up to 6 months in jail. So it's in your best interest, certainly, to comply with all the conditions of this delay. So the court is going to place you on a delay of sentence for a period of 1 year. The court's going to adopt as the conditions of that delay all the terms and conditions listed in the report. So it's important for you to go through those with Mr. McFelda so that you understand what you're going to need to do over the past year. The court is going to order a convict assessment of $130, court costs of $325, attorney fees of $350, DNA testing fee of $60, and a $68 state cost, as well as a supervision fee of $30 per month during the course of the delay. Because this is a delay, the court is not imposing or giving any jail credit this time, and there are no appellate rights. So are you going to meet with Mr. Wilson before he leaves?
Yes, he's gonna wait in the lobby until I'm able. I already
So
just
Mr.
spoke.
Wilson, just make sure that you stay until you have a chance to talk to Mr. McFelda today, and good luck going forward.
Your shot. Given the delay, would appellate rights be premature?
Yes.
All right, thank you.
I just do them because I never know how things are going to go.
No, I understand.
Better to have them, but
Wanted to make sure you didn't need them back.
Do you have Mr. Sherbet present?
I do not see him in the courtroom.
People versus Evan Sherbet. This is file number 55482. This was set for hearing at 10:45. It's now 5:50. Call the court. I do not see anybody present by Zoom. If you had any contacts with
I am checking.
looks like we adjourned the hospital.
He was in the hospital and he got an admission So he was approved for admission to a VA facility in Milwaukee. And that's the last update I have, is that that was approved. So I don't know where he is, Your Honor.
Well, I certainly have that as part of the sentencing considerations. I don't know that the court ever approved the bond condition or anything else to go to Milwaukee for any reason. So as far as you're aware, he's not currently still in the hospital in Marquette.
I don't know that, Your Honor.
So
We have no information at all. We would ask for a bench warrant for failure to appear.
I think that's appropriate given that this is the sentencing hearing. Recommendation for jail, so we'll prepare a warrant or sign that. We'll proceed further on Mr. Sherwood's case once he's arrested. That's okay. Ms. Stead, are you able to hear me okay?
Yes.
All right, we'll go on the record in People versus Sandra Stead. This is file number 255495. Record should reflect Ms. Stead is appearing today by video from Department of Corrections. This is the date and time set for a sentencing hearing. Mr. Thompson, did you have a chance to go through the PSI with Ms. Stead?
I did.
And Ms. Stead, did you have an adequate opportunity to go through that report with Mr. Thompson?
Yes.
Okay, Mr. Thompson, are there any additions, deletions, or corrections to that report?
There are, Your Honor. At various points in the report, it refers to this occurring on May 21st versus April 30th. We believe the May 21st date is correct. So if you look at, for example, on page 2, it indicates on 5/21, that's when Sting applied for and got a search warrant. That's when they found the things that form the basis of the charge. So we're asking that the references, for example, reflect 5/21/25, same thing on the conviction information on the sentencing information report offense date. This occurred on 5/21.
So if you have any objection to correcting those dates?
No objection.
Okay. Any other changes, Mr. Thompson?
No, Your Honor.
Any challenges to the scoring?
No.
So do people have any additions, deletions, or corrections?
No.
Any challenges to the scoring?
No.
Anything on behalf of the people for allocation today?
Your Honor, the sentencing in this case, frankly, given that she has that sentence in Ross Common for 4 years, isn't really controlling. I've been dealing with Ms. Stead since she started committing felonies. So I'm sad that she ended up here. Seems like she works hard to stay in the criminal justice system and in the prison system. So I'd ask the court to follow the recommendation. Thank you.
I mean, first of all, I do agree, given the posture of the case and the fact that it's concurrent sentencing, that Ross Common sentence that she's sitting on is essentially controlling. She got 4 years there. So I do want to say, though, I mean, Ms. Stead is a person with a lot of potential. She's a very hardworking person. She's a very gritty, determined person. She loves her children very much. She really is a person with a lot of potential. And she's certainly, someone who got into a relationship here that really was her downfall. And I'm really hopeful that, when she's released, she's not going to be in that kind of relationship, not going to be in that kind of position where these kinds of things can happen to her, and really get back on track, because she really was a very hardworking, good mother, doing a lot of things very well in her life. And I know she can do that again. Thank you.
All right, thank you. Ms. Stead, I had to mute you because there was some background noise, but I don't know if you have to press something on your end to unmute. All right, Ms. Stead, was there anything that you wanted to say today?
I, again, like he had said, it was a not putting blame on anything, but relationship courses. I have got my GED, so I'm gonna work hard to get into Vogue Village and do things differently.
Okay. All right, instead, I did review the pre-sentence report in this case, so I am familiar with what happened, the circumstances that bring you before the court on these charges. The court, also, there's a lot of information in that report about yourself, your background and your personal circumstances. And I take all of that into account along with what the lawyers have had to say here today. I do hope that this is something that you can move forward from. You know, as everybody's indicated, the sentence in this case is going to be served well before the sentence in your other file. And so I know that you're going to be lodged there at Department of Corrections for a period of time, and I'm hoping that you'll use the resources that are available to you there to make improvements, to get yourself in a position that once you are released on parole, that you can move forward from this. In this case, the guidelines are 10 months to 23 months. I do think the recommendation is appropriate. It's for 15 months in the Department of Corrections. It's right in the middle of the guidelines. And again, it's going to run concurrent with your current sentence. So you're going to serve this sentence much, you know, well before you're released on the other one. So the court is going to sentence you to 15 months to 10 years on this file. You do have credit for 91 days served. Order a crime victims assessment in the amount of $130, court costs of $325, attorney fees of $350, and a $68 state cost. You do have the ability to seek an appeal of this sentence. If you haven't already received it, we will be sending you some papers that explain to you what your appellate rights are, as well as how to request a court-appointed attorney to help you with any appeal. The time limits on that won't start running until you receive those papers and acknowledge receipt. So any delay between now and when you receive them won't be held against you in terms of when you can file for your appeal. Otherwise, good luck going forward. Did you have any questions at all?
No.
Okay. All right, thank you. The court's going to disconnect at this time.
Your Honor, just.
Thank you.
Is the court going to send her appellate rights, or do I have to do it?
Mr. Thompson, no.
All right, I'll file the proof with the court. Thank you.
People versus Nicholas Fennell, case number 255455.
Sierra Cook on behalf of the people.
Judge Mike Claxton on behalf of Mr. Fennell.
Mr. Hamlin, are you able to hear me okay?
Morning, Judge. Yes, thank you very much.
Okay, good morning. So this is the date and time set for a sentencing hearing in this matter. I know that had a lot of back and forth on this case in terms of what procedurally was the correct thing to do. So we're ready to move forward here today. It's my intention, of course, I think based on what we discussed in the past, to sentence Mr. Fennell to probation, with the main term of that probation being that he participate in and complete the drug court program in Otsego County. And Mr. Hamlin, is that something that you're ready to go forward with and accept him into that program?
Yes, Your Honor. He was accepted last year, say around September of 25, and placed on bond conditions. I believe his attorney has a copy, and maybe the court might have a copy today as well.
Okay. And is that your understanding as well, Mr.
It is, Your Honor.
Okay. So all of that being said, Mr. Fennell, have you had a chance to go through the pre-sentence report and talk to Mr. Claxton about it?
We reviewed it yesterday.
Okay. And Mr. Claxton, are there any additions, deletions, or corrections?
Judge, no additions, deletions, or corrections per se. There are two items to talk about, but they are correct.
Okay. And are there any challenges to the guidelines?
I believe the guidelines are accurately scored, Judge.
Thank you. Ms. Cope, do the people have any additions, deletions, or corrections?
No.
any challenges to the scoring?
No.
Anything on behalf of the people for allocation today?
You know, I really struggle with these cases where somebody doesn't get any jail time at all when their drunk driving history is impaired 2017, and OWI 2021, and OWI 2023, and then we're back here again for another drunk driving, and his blood alcohol was, you know, double the legal limit. So I also understand that sobriety court is a very good tool. And I think it's appropriate that he get into it, because if we continue down this path, you know, he's fairly young at 31 to have this kind of criminal history. And, you know, he's headed towards prison if he doesn't kill himself or somebody else, if he continues down this path. So I would defer to the court as to what's appropriate, given the sobriety court. This court's more familiar with the sobriety court in Otsego than I am. So thank you.
First of all, Judge, if you didn't have those bond conditions, I do have a copy for you.
I did.
Okay. Judge, I wanted to start by acknowledging, I realize it's been a headache for everybody. I want to apologize to you. I want to apologize to Ms. Medler. I want to apologize to Ms. O'Rourke, Mr. Hamlin. It's never my goal to create a headache, Judge, and to the extent that I'm confident I probably did cause or contribute to miscommunication or confusion. I apologize, Judge. That's certainly not what I'm trying to do here. So I do feel that I owe you with Ms. Medler and everyone else an apology. Furthermore, Judge, I'm aware that you did extra legwork figuring this out, getting it to happen. Thank you, Judge. On a professional level, I appreciate that. As to Mr. Fennell, Judge, I think Mr. Haven did an excellent job on the PSI. I believe the scoring is accurate. As I said, I am going to ask the court to follow the recommendations. The two quick points I wanted to make about the PSI, Judge. Again, not a correction per se, but on page 3, I think it's item number 22. It discusses a probation supervision fee. It's come to my attention that that's somewhat, I guess, duplicative or redundant in the sense that Mr. Fennell will also be paying for a supervision or oversight fee to the sobriety court. In that regard, Judge, I'd ask you to strike number 22, but I believe that's essentially, it's your call. It's not mandatory.
Right, so we addressed that. I had another individual earlier that was going into waiting for, I believe, is that your position as well, Mr. Haven? That
Yeah, I've understood other defendants that have been able to waive that if they're in a treatment court.
Yeah. So I'm going to strike paragraph 22 based on that. So I'm aware there's significant fees associated with supervision in the
Second sort of logistical issue, Judge. As the bond conditions indicate, and as Mr. Hamlin has said, Mr. Fennell has been participating in sobriety court voluntarily since November 5th. Mr. Hamlin or Mr. Haven can correct me if I'm wrong, but my understanding is that as the sentencing judge, it's up to you, it's your discretion, whether that time participating in the program up till now could be counted towards completion of probation. And I think what makes sense to me, Judge, certainly again, it's your choice how to handle it. I would suggest just punting it to Judge Hessling. If in November of 2027, he feels as though Mr. Fennell has complied with probation, is ready to release him, great. And if he doesn't, then he won't. Rather than make that decision today, I think it makes sense to see how he does and let Judge Hessling make that decision. But ultimately, Judge, I think it is your choice.
Can I say something about that too?
You're going to have a chance, Mr. Fennell, in just a minute to tell me everything that you'd like to say. Sorry.
Judge, one last thing. I know the court is sworn today. I wanted to make the point. I recognize that everybody who comes to the court for sentencing is a change agent, right? Everybody comes for sentencing ready to do different and turn their back on their past and their criminal history. I learned a few weeks ago that Mr. Fennell, because of his time in the program, was given the opportunity to face up. And I was a little bit surprised to hear that his response was no, that he felt he needed the level of responsibility, of accountability, of testing that he was currently at, and he was not ready to phase up. again, Mr. Hammond will know better than I, but my experience is that that's not a common response we get from people. When they're given the opportunity to phase up, it's usually, yeah, yesterday, right now. Through the duration of this case, just the past 5-6 months, I do feel that I have seen a shift in Mr. Fennell in terms of taking responsibility and doing something different, not doing the same thing that got him here. By all accounts, he is working the program. He's taking it seriously. It's going well. I know he's very grateful for the opportunity and everyone's contribution, literally everyone's contribution to making it work. I think that sort of shift, that recognition, that awareness is one of the things the court wants to see at this stage. And frankly, as a result of every criminal case, I'm optimistic he can successfully complete the program. That being said, if he doesn't turn things around, if he has issues, I'm very aware that he'll be dealt with accordingly in the program. Nobody gets a free pass in sobriety court, as Your Honor is obviously aware. I just hope, Judge, that this case can be a punctuation point in criminal history, and I believe he can do that. I'm optimistic. Thank you.
Thank you, Mr. Fennell.
Yeah, I'd just like to point out, I knew that what I did was wrong, and not just this instance, but in the past, and I should have learned my lesson sooner and not gotten to this point at all. But I went off to, my drinking was leading me down the wrong path, and it was going nowhere positive. And I plan to look ahead and keep my life organized and keep drinking completely out of my life. That date, I've been sober since, what was it, June 7th or 6th, I believe. I've 246 days sober and been in the program for 95 days and looking to phase up here this coming Tuesday, now that I've met that 90-day mark, and really looking forward to that accomplishment.
All right. Well, obviously, I'm very familiar with your case. I read through the report, though. I'm familiar with all the information that is in that report, including information about this offense, as well as your prior record and prior history. And one of the things about your prior history, I think you're the type of person that the treatment courts are looking for, somebody who has a genuine problem. People that don't have a problem that quit drinking and make this a one-time thing don't really get that much benefit from the treatment courts. They can sail through it and it's no problem. But they're really designed for somebody like yourself who's a repeat offender, who's demonstrated that there's an issue that they can help with. So from that standpoint, I think you're a good candidate for the program. And it is an opportunity for you to get some skills, to get some tools that can help you deal with the underlying issues here that lead to the criminal behavior. And that's what's the benefit to the community. You can do that, move forward, and not reoffend, then we're all safer and we're all better off. You're better off. You're going to live a more productive life, one that's going to be more satisfying to you, and one that's not going to result in spending time in jail. So I hope that you take the program seriously. I say this to everybody who goes in, because I did preside over a sobriety court for a while, several years, and I know the people that were successful were the people who were doing it because they were sick of constantly getting in trouble and constantly being on probation. They wanted to make change in their life to move on from that. People who do it because they were ordered to, or because they got a better deal, or to avoid jail, weren't as successful. It's the people who really want to do it for themselves and end up getting through it successfully. So I hope that you go into it with that point of view, and that you successfully complete it, because again, that's the outcome we're all looking for. If you don't, however, I am going to impose some jail time. I'm going to hold that in advance. I want you to understand that if you don't make it in the sobriety court, you're violating, if you are testing positive, you come back here, there's going to be a significant jail sentence waiting for you, because at that point you will have demonstrated to me that this chance is working out, that those other things are more important to you than staying clean and staying sober. So the court is going to place you on probation for a period of 24 months. I'm not going to direct the sobriety board when they can or can't graduate you from that, discharge you successfully, but you will remain on probation here for 2 years from today. So even if you complete the sobriety court program earlier than that 2-year period, the supervision will come back here and you'll still be under probation here and under all these terms and conditions for that 2-year period. I think that's important. I think it's really encouraging that you've done well so far, well on bond and as part of the program, but I think given your history, the longer we have you on supervision here, the more assurance we have that you can stay on that path. So the court is going to sentence you to 2 years of probation. Again, with the prime term of that being participation in a successful completion of the Otsego County Treatment Court Program. We're just going to adopt as the conditions of your probation all the other terms and conditions listed in this report. The court is going to order that you serve 9 months in the Otsego County Jail with credit for 1 day served. That time to be held in advance to be served at the discretion of the court. The court is going to order restitution in the amount of $150 payable to the Crawford County Clerk to be dispersed to the prosecutor's office. Crime victims assessment of $130 for costs of $325. Reimbursement fee of reimbursement fee of $100. $68 state cost. And a fine of $500. Again, the court is striking the supervision fee. You do have the ability to seek an appeal of the sentence. Mr. Clackstead next to you on that table are the acknowledgement of Mr. Jones' appellate rights. Have them acknowledged receipt of those, please. Mr. Hamlin, was there anything else you needed from me or anything else that you needed to state for the record today?
I have just one question for the court, Judge, because I don't have a copy of the PSI. I'm curious if there's any community service listed on there, and if the court would strike that because he is actively participating in the program and our phase requirements do have community service hours they have to complete. Probably not at the amount that's on the PSI, but I'd be curious what the court's take is on that.
Yes, if community service is part of participation in the sobriety court program, then I'll strike that. That's paragraph 9.
Thank you, Judge.
All right, Mr. Beck, anything further today?
No, no.
Does Mr. Fennell need to meet with you before you leave?
Yes, I'll meet with him and go over his probation order.
All right, Mr. Fennell, good luck to you.
Thank you.
Thank you, Judge.
All right, thank you, Mr. Hamlin. You're free to disconnect. And then Mr. Kroll, if you come up forward to the podium, please. We're on the record at People versus Kroll. This is file number 255497, 265512, and 265513. The record should reflect that you're present here in the courtroom today. If I could have counsel.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Jason Thompson on behalf of the defendant, William Kroll.
So for the record, I did receive a victim impact statement from Lake State Railway. I did receive a number of letters on behalf of Mr. Kroll. I had a chance to review all of those letters prior to the hearing today. And Mr. Thompson, did you want those attached to the precinct report?
I did, please, Your Honor.
So I will attach those. So Mr. Kroll, just so you're aware, I did receive those. I had a chance to read them.
Thank you, Your Honor.
Mr. Thompson, are there any other additions, deletions, or corrections?
There is a small correction to the PSI, Your Honor, going to the employment section. Sorry. Which is the type, I think it's a typo, but when it indicates Tracy worked for Mr. Freeman, that's to the present. That did end in October of 25, which is consistent with the next employer picking up that in October.
This says date December, but that should be October.
Yes.
Any objections to that change? So,
No.
any other corrections?
No, Your Honor.
Any challenges to the scoring?
No challenges to the scoring.
So, do the people have any additions, deletions, or corrections?
No.
Challenges to the scoring.
No.
Again, I did receive the written statement from Lake State. Do you have any other victims that wish to address the board today?
Jeremy Craig indicated he was going to be here to speak today, but I do not see him in the courtroom. I just want to confirm he's not on Zoom.
No.
Okay, then no.
Anything for allocation?
Your Honor, Mr. Kroll really wasn't not even somebody I had ever heard of until I couldn't stop hearing about him. Just over and over and over, he was on bond. He commit more crimes, he on bond, he commits more crimes. One of the charges in here is the stalking. He continues to talk about his fiance. He did it in his district court sentencing. There is a PPO in place. Despite that, he continues to contact her. There's a new police report and it depends on what today's sentencing is, what I'm going to do with it. But even with all that PPO in place and the no contact order, he continues to contact Marissa Pagolio. I think 37 times he has contacted her since December 6th. Despite that, knowing that the calls are recorded, he's in jail and he still makes those. The police report indicates, and I haven't reviewed those calls. The police report indicates that at times he's argumentative with her, at times he's intimidating, at times he's threatening. And she indicated that she's even been contacted by his mother. It doesn't say what those contacts are. I think there's some stuff that needs to be, he has some of her stuff and she has some of his stuff. But either way, he doesn't follow the court orders. He doesn't follow his bond conditions. I know that the recommendation is a jail sentence, but I think that a prison sentence is more appropriate. I think he would be a really good candidate for the boot camp program if he was accepted into it. You know, he's fairly young. He's got this history of, 9 misdemeanors, but until recently, he had no felonies. I don't know what happened to Mr. Kroll. I've seen some of the videos of his behavior in the home. He obviously has some anger management, and this relationship that he was in and he conceives he's still in is all part of the problem because they all tie in together. The larceny, he did it with her. The breaking and entering was her neighbor's house. This has just been a series of crazy events. The police started at one point responding to a call at this house and he was digging up dead bodies in the yard is what he told them. There seems to be a substance abuse issue or mental health. I'm not really sure what's going on, but there isn't a lot of likelihood that he's going to follow those court orders, even though Marissa Pagolio has said, I don't want him to call me and I keep talking to him because I'm scared of the times he told me he's going to kill me if I don't. So they have stopped his contact to her by having to block her phone number in the jail. It's the only way we could stop it. And I think that given his long history, all the stuff that he did while on bond, I think it's appropriate to do middle prison sentence. Thank you.
Yes. One of the things you said reminded me of a question that I had when I was reading through the report. Mr. McFelby, did the PSI generate?
Yes, it did.
It looks like the plea was entered in this case on January 8th. And in the report, did it indicate that Mr. Kroll, even after the plea was entered, was attempting to contact
That's correct, Judge. Yeah, I stopped tracking the dates after January 20th.
Okay.
But from this, when my report was done, I don't know what he's done since that date, but up until January 20th, there was 38 times he made calls to her with making contact on 7 of them. That was from December 6th of 25 to January 20th of 26.
All right, thank you. Mr. Thompson. Yeah.
I have a few things, Your Honor. I received a letter from Mr. Kroll's mother. I'm sure the court reviewed it. I'm sure the court can empathize with her position and her statements where she, acknowledges what occurred, but she also offers and assures the court that she is strong family support for Mr. Cole. I think that's important as the court looks at its options here and weighs what to do. I think if the court went down the road of prison, as Ms. Koch is suggesting, that it would be appropriate to allow him to do boot camp. However, I do want to advocate to follow the recommendation and to impose a jail sentence. And in doing a jail sentence, I'd also ask the court to consider concurrent sentencing instead of consecutive sentencing. Mr. Kroll is a very young man. He's 25. He could have even potentially received hideout on these. That's not the offer. That's not where we're here today, but that's the kind of age he is. And it's been alluded to earlier today. Young men are still developing at 25. Their brains are still developing. And Mr. Kroll is a person who had made mistakes in the past, but it really did accelerate this year. And the thing that struck me in reading PSI was when he got to the substance abuse section, methamphetamine started at 25. And I don't think it's a coincidence that that's when things did accelerate with his criminal history. That's been my observation doing this job for however long I've been doing it, in terms of methamphetamine accelerates things in people's brains. It's so destructive to our community because of that. It's hard to explain or defend some of the things that happened here, but I will say that Mr. Kroll is a person, he's full of potential. He's a very bright person. He's a very hardworking person. He's a very energetic person. I think if he did get a county jail sentence, one thing that would be in front of him would be that opportunity for trustee status. I don't believe he's there yet from talking to the jail, but I think that would be a strong incentive for him because of the amount of time he would earn if he were to become a trustee. Blocked Ms. Pagilio's number. I think that relationship has proven really to be disastrous for Mr. Kroll. I hope, saying it in different ways and seeing the effects of it will really drive that home. I think he intellectually understands where he's at with that case, but now he's got that situation, but now he's got to live it out every day. We all know in this job, that's the real challenge is living out the change you want to achieve in your mind. So I do think Mr. Kroll is of an age and with a support network and in circumstances that do suggest perhaps this can be a blip on the radar. Perhaps this is not his future. Perhaps this is, that bad, really bad couple months he had in 2025. But overall, he gets back on track, gets his life going. I have high hopes for Mr. Kroll. I hope the court will consider concurrent sentencing here. I think these occurred very quickly. I think this is a gentleman without a felony background. And so I do think in a certain way, I look at this as a series of related transactions. Would ask the court to do the same and to oppose concurrent sentencing. Thank you.
Thank you. Mr. Kroll, anything you wanted to say?
Sorry, Your Honor. I was hoping I could make it further than this without getting emotional. Is there any chance you could just read my letter? I have 2 pages written for you.
Certainly.
Yeah, they're marked 1, 2, 3, and 4.
is there anything else that you wanted to say, Mr. Kroll, in addition to that?
Oh, yes, sir. Yes, Your Honor. Oh, I just want to stay in front of this court, an apology to Jeremy. He's a good friend. So I'm just at a loss for words, like I said. And I just want you to know with conviction that I have a lot of big goals, dreams in my life. And my mother and father know that very well, that I'm capable of achieving them. And I know it very well in my heart. And my vision for the future is never been more clear.
All right, well, Mr. Kroll, again, I did read all the letters that were submitted. I read through the pre-sentence report, so I'm familiar with each of these incidents that were convicted on. There's also a lot of information in that report about your circumstances, generally, your background. So I take all of that into consideration, along with what the lawyers had to say and what you had to say through your letter there. And it's always interesting to me, and I certainly, as a parent, I feel for your mother, her letter that had a lot of impact on me, because I think we can all imagine ourselves in her position where she sees you in such a different light and knows the good qualities that you have and have experienced those. And the other people that wrote letters on your behalf and were very complimentary of you in terms of your work ethic, they all expressed surprise that you're at where you're at right now. And so that indicates to me that they all see some good qualities there and they must be there. And they're all looking at you from that perspective. And I think they're probably wondering themselves how you ended up in this spot. And from my perspective, I can appreciate their points of view on that. But I also have to look at your behavior. And going back to the time that you were in the service, the problem started almost immediately and continued. And then once you were discharged from the service, they really continued. It wasn't too long after your discharge that you had your first charge as a civilian. So something clearly has gone awry. The charges in this case, I was really struck by the statement from the railway. I thought it was very interesting, even though it was an economic loss for them. They certainly, it disrupted their operations. It created a larger safety issue, and there were ripple effects from that. And I appreciate the statement from that, because that was something that I didn't fully appreciate, the type of effect that the theft of those materials had on their operations and in a larger sense of public safety. Your actions with regard to the stalking and the breaking and entering, it is very concerning to me that knowing that there was a personal protection order, knowing that your bond conditions prevented it, knowing that that everybody was going to know that you were making these calls because they were coming from jail, you still continue to do that even up to recently as January 20th. That indicates to me that there's a real issue with self-control here, that in light of knowing that there's going to be negative consequences from that, you continue to do it. A lack of recognition that these are court orders, that they're not optional. It's not up to you to decide whether you're going to follow them or not. You have to follow them. And just again, the fact that there was no way that this wasn't going to be discovered. And so that to me is concerning from the standpoint that I don't know that right now you're capable of following through with probation, capable of exercising self-control that's necessary to abide by the conditions of probation on your own. Because even in a jail setting where literally the jail has to stop you from being able to make that contact, that's the only way that it's stopped. You can't even do that in a jail sentence or in a jail setting where it would be easy to just not do it. You're out in the world, there isn't anything stopping you really from doing it. And So I just don't have any confidence based on the behavior that you would be able to independently voluntarily comply with conditions of probation. And I think as a whole, looking at this situation, I think a better solution here for you than probation and local time is a prison sentence. I don't have any objection to you participating in the boot camp program. I think that might be helpful for you. It's certainly more rigorous than what we would have the resources to provide in terms of probation. And again, given the way that things have gone, I just don't have any confidence that you would be able to follow probation. And I think we would end up back here on a violation relatively quickly. So,
Your Honor, is there any chance I can speak real quick?
sure.
So to explain my calls to Marissa, when I broke up with her officially, she threatened to end her life. And that's why I called the police that day, that she disappeared, and told them about the bodies that might have been buried in the yard. And honestly, we were on good speaking terms for every one of those calls. And she told me she looked forward to those calls. And I was doing it to try and ease the pain of the separation, in honesty. And if you look at the bright side, not the dark side of maybe we yelled at each other a little bit on one or two of the calls, which is normal quarrel. It was really, we told each other we loved each other. We still wanted to get married. We were still on good terms. And I was really just trying to smoothen the transition for our separation, because we're still technically engaged, and that has come to an abrupt halt. But I just didn't want to live the rest of my life blaming myself for her ending her life, because I believe right now she's in that position, and there's nothing I can do to stop her. She lost her kid. She lost her dog. Her house just got broken into by raccoons like 2 days ago. She's sleeping in her truck. I think she's very close to ending her life, and I will blame myself if she does. That's why I made those calls, Your Honor. Thank you.
Well, again, it's not up to you to decide that you make those calls or it's appropriate. You're supposed to do it, and you did it. And again, that just continues to show me that you're going to exercise your own judgment about when you think you need to follow orders and when you don't. So it just proves my point even more what you just said. So the guidelines are 7 to 23 months and 5 to 23 months. I think a reasonable and appropriate sentence is 18 months in the Michigan Department of Corrections. So that's to count one in file 5497 for consents to 18 months to 5 years in the Michigan Department of Corrections. You have credit for 2 days served on that file.
Respectfully, when we get to the breaking and entering the building, is the court sentence here, is that concurrent then to MDOC sentences concurrent? Okay, I believe you'd be entitled to the 64 days as to the breaking and entering, and because that bond was not posted, look at page 1. The way I took the recommendation was there's a recommendation of no credit because of the recommendation for consecutive.
That, what he's saying is accurate. I just gotta, yes.
Yeah, because Mr. McFall.
If it is concurrent, yes, then he's correct. 64 days would be the credit on 5512.
So that wasn't a correction, because it's dependent on what the court.
Right. So yeah, I mean, because the court is sentencing, imposing a prison sentence, I'm not going to impose the consecutive sanction, because essentially the prison sentence is time spent. Right. So that's as to 5497.
Just to confirm, we're doing 18 months, 5 years, credit for 2 days.
Correct. On 5497. On that file, restitution in the amount of $1,184 payable to the Crawford County Clerk to be dispersed to W Auto Parts. Crime victims assessment of $130, court costs of $325, attorney fees of $350, DNA testing fee of $60, state cost of $68. As to file 5512, and that's the breaking and entering of intent, charge 18 months to 10 years, credit for 64 days served. On that file, a crime victim's assessment of $130 and $68. On file 5513, 12 months in the Crawford County Jail with credit for 64 days served, crime victim's assessment of $130 and $50 state costs. All the sentences can serve concurrent to each other. And again, the court will have no objection to plea camp. Mr. Thompson, if you can provide Mr. Kroll with this.
So Mr. Kroll, these are two sets of appellate rights.
Do we have to discuss the contempt?
If you initially hear you're acknowledging you receive them, this doesn't file the appeal. To file the appeal, you'd have to fill it out. If you want to request an attorney, there's a section for doing that. First time it's due within 14 days. Yep. You type this out either from this jail or from the prison. Start your appeal. That's what you want to do. I'll leave you with 2 of these copies. If that's what you choose to do.
Contempt.
Issue on the 5513.
Hold on one sec, Mr. Kroll.
Well,
Mr. Kroll, sorry, your case.
Okay. All right, so the contempt charges are dismissed. And I am going to decline the new case that will allow him to go to boot camp. If I charge it, it would stop him. So I'll get that decline letter done today or tomorrow so that he should be clear for boot camp.
That's all for today.
Okay, thank you.
Got it. Thank you.
It's in my packet before we recess.